Good afternoon, everyone. It's 1:30. I'm Jerry Catrier, Chairman of the Board of Zoning Appeals, and I call the October 26th meeting of the BZA to order. Teresa, are we in compliance with FOIA?
Yes, sir, we are.
Okay. We begin all our meetings with the Pledge of Allegiance. Please join me. I pledge allegiance to the flag of the
United States of America and to the republic for which it stands, one nation,
under
God, indivisible, with liberty and justice for all.
Thank you. Teresa, would you call the roll of the members?
Certainly. Mr. Johnson?
Bob, you need to unmute your phone or your speaker. Bob Johnson, can you hear me? You need to unmute your speaker or your microphone. I see Mr. Johnson. We'll consider him present. Let's go on with the roll call.
Thank you, Mr. Chairman. Mr. Walzak?
Present.
Mr. Catrier?
Present.
Ms. Bryson?
Present.
Ms. Loudermilk?
Present.
Mr. Chairman, Mr. White and Dr. Ponder are excused.
I understand. Thank you. It appears that we have a number of other people present. Missy Lewick, Nicole Dixon. I'm not sure how to pronounce Miss Irvin's name? Josh Gruber, Mr. Bowen, and Curtis Coltrane. The procedure that we will follow today is to go through our approval of agenda and approval of the minutes, and then we will hear an appeal. I'll go over the specific procedure for that when we get to the particular appeal. Looks like we're working on trying to get Mr. Johnson microphone turned on. Bob, if you can hear me, would you wave your hand at the camera? Okay. And you might
Can you
turn
hear me now?
Well, we got you now. Terrific.
Okay, I'm not going to touch anything again.
Okay.
On orders of my wife.
You might want to turn your, I don't know whether you're on the laptop or what, but all we see is your eyes up. You may want to move it a little more so we can see all of you. First item of business is to approve the agenda. The agenda's been published. Does anyone have any changes to make to the agenda? Hearing none, I'll ask for Ms. Bryson. Were you about to?
I move approval.
Okay.
Second.
Second by Loudermilk, motion by Bryson for approval of the agenda. Any discussion on that? If not, I'll call for a vote of acclamation. If you're in favor of the agenda, say aye. Aye.
Aye.
Aye.
We'll move on to the minutes of the September 28th meeting. Those minutes have been circulated. Does anyone have any corrections or changes to those minutes? Hearing none, I'll entertain a motion to approve the minutes as submitted.
I'll move we approve the minutes as submitted.
Motion by Walzak, second by
Second.
Loudermilk. Teresa, would you call the roll?
Mr. Johnson?
Present.
Vote should be for the motion, Bob.
Oh, for the motion. For the
Mr.
motion.
Walzak? Thank you. Mr. Walzak?
Yeah, I'll be for the motion.
Mr. Catrier?
For the motion.
Ms. Bryson?
For the motion.
Ms.
Actually,
Loudermilk.
you voted for the motion. Actually, I should correct myself, Bob. You had the option of voting for or against the motion. Teresa, could you address the issue of public comments for the meeting?
Certainly, Mr. Chairman. Public comments concerning agenda items were to be submitted electronically via the Open Town Hall portal. The portal closed 2 hours ago, and there were no comments of record. Citizens were also provided the option to give public comment on agenda items by phone. There were no requests from citizens to comment by phone.
Thank you. I might point out that the case that's before us today is an appeal, and pursuant to the procedures of the BZA, no public comment is accepted on appeals. We had several items, requests for variance that have requested postponements, and pursuant to the authority granted me under the rules of procedure, as chairman, I have granted postponements to 131 Sandcastle Court, 127 Sandcastle Court, and 125 Sandcastle Court. These items are placed on the agenda today for the purpose of establishing an official hearing date, and that is the date from which the postponement will proceed. I might also say that I refused or did not grant several requests for postponement that are to be heard on our Thursday meeting, all relating to Sandcastle Court. Those that I granted and have granted in the past, I felt in my judgment were warranted. The three, I believe it was, that I denied, I did not feel their reasons for requesting a postponement were justified. We'll move on now to the new business.
Mr. Chair, I'm sorry. For the record, I believe you said 131 Sandcastle. My agenda shows 121, just for the record, to make sure it's the right number.
It's 121 as published in the agenda.
Great, thank you.
We'll move on now to an appeal. Appeal 000760. 2020, a request from William Bowen, PA, on behalf of Island Club 3 horizontal property regime. Appellant is appealing staff's determination dated March 24, 2020, that an unimproved right-of-way off Folly Field Road, currently functioning as a drainage, easement, and pedestrian access to the beach, is classified as a street and requires an adjacent street setback and buffer from it. The procedure that we will follow for an appeal is that the appellant will be offered 20 minutes to present the basis for their appeal. Staff will, and at the conclusion of, or in fact during the appellant's presentation, board members may ask questions of the appellant. Following that, staff will be granted 20 minutes to state the staff's position on the appeal, and board members will have the opportunity to ask questions of staff. If the appellant is someone other than the property owner, then the property owner, if it so wishes, would also have 20 minutes to make a presentation. At the conclusion of the presentation by the appellant and the staff and the questions by the board, there will be an opportunity for each party to have 5 minutes to submit any rebuttal arguments they wish to make. As stated earlier, appeals before the BZA do not allow for public comment. At the conclusion of all of these presentations and questions by the board, then the board will have a discussion among itself and leading to a motion and a vote to either uphold or deny the appeal. I need to ask Mr. Bowen, you are present. Your microphone on, sir?
Yes, excuse me. Yes, I am.
Okay. You are representing the Island Club 3 horizontal property regime, and are they in fact the owner of the property in question?
Property. I'm sorry. Okay, I'm not used to this sort of communication, so you'll have to bear with me on this. But yes, the regime owns a piece of property upon which we wish to place something, and upon which we're asking for a variance from setback requirement for a street.
Okay, we just needed to establish that the appellant is in fact the property owner, and so there's no need for an additional party to make a presentation. Okay, Mr. Bowen, you appear to be looking off to the sides. You may want to look at.
Where
I know this is.
I'm trying to look at you.
Okay, well, don't look at me. Look at your computer screen.
Okay.
And there should be a little green light, and that way you're looking at all of us.
How is that?
That's perfect.
All right.
So,
good.
With that, sir, you have an opportunity here to make your presentation for your client. And so, Teresa, start the clock going. Mr. Bowen, you have 20 minutes, and the floor is yours.
Well, I hope it won't take that long. I don't know if you all have had an opportunity to read my statement of facts and the brief that I submitted, which is not too long, but I will avoid repeating what's in the statement, other than to really summarize it. Our basic position is we're trying some time ago, and I don't remember whether it was in late 1990 or early 20s. A structure was placed upon the area in question, which is served as a dispensary, if you will, for various items that are needed from time to time in the project. Refrigerators, washing machines, dishwashers, dryers, et cetera, et cetera. They need to be on site where they can be replaced quickly if necessary. In any event, a structure was placed on there, I think more than 20 years ago. At that point, required no approval. But the structure is, excuse me, turn this off. The structure is in bad need of repair or replacement. It's deteriorated beyond the point where it can be repaired. In the process, because of the various review committees that exist today, they were required to apply for a location permit, a building permit. I'm not sure exactly what you would call it, but in any event, they wanted to place this structure right on their property line, and they were turned down because it said that there was a 20-foot setback from a street. Now, the property in question I have had reduced to a plat with some photographs on the plat showing the different locations. My first point was that the lane or the criteria established for a street does not exist. It does not exist in the LMO, which states it is a street is an existing or planned public right-of-way or private easement used or intended to be used primarily for carrying vehicular, bicycle, and pedestrian traffic, and providing for a principal means of access to abutting properties. Now, the lane does not meet that criteria. I'll try and continue looking at you, but I won't. Do you all have the plat available that I presented? Do you all?
We do. Let me interrupt you a minute and ask the staff, is it possible to put that plat up so we can all see it? Missy or Teresa or Nicole?
Yes, Mr. Chairman, we can pull that up.
Okay, great.
Okay, great picture. In the upper right-hand corner, you will see a picture taken from Follyfield Road that shows that the lane does not reach Follyfield Road. That's picture number 1. Picture number 2 shows a drainage ditch which goes across, and if you look to That picture right there, you see they're numbered on the screen to give you an idea where picture number 1 is.
Well, we just lost the picture.
Maybe I did something wrong.
There we go.
Okay. The purpose of picture number 1 is to show that the lane does not reach Folly Field Road. So it's clearly it can't be used for vehicular access because across the lane, it's shown in picture number 2, there's a drainage ditch, which is approximately 20 feet wide and 10 feet deep. That would be immediately behind the background of picture number 1.
Mr. Bowen, I want to ask you a question here.
Sure.
The text under the photos is a little difficult. It's very small. Picture number 1 is the upper left-hand corner.
Yes, and it says.
And number 2 is the upper right-hand corner?
No, the number 2 is the one right below it.
Okay. So 1 is upper left and 2 is lower left. Okay, got it. Go ahead.
Can you read the caption itself?
Yeah.
Okay. And then when you go to picture number 2, that's the drainage ditch that bifurcates the quote lane end quote, so that it cannot be used as access to Folly Field Road because there's a 20-foot ditch that runs across it. Picture number 3, excuse me, shows the end of Moonshell Lane, which does not, the area that you see that is not paved is the subject, and it's marked somewhat with red lines, is the area of the lane. Moonshell Road does not extend into the lane. The picture of number 4 shows you the end of Sandala, the end of the pavement of Sandala, which does not intrude onto the lane. So there's no access to abutting properties provided by the lane, which again is one of the key elements of the description and the statute as to the definition of a road. I have given you all the statements that I can find from every known source of the English language in terms of what a lane is, or rather what a lane is not. And in the case law and statutory interpretation and in dictionary interpretations, this does not meet the essential elements for a street. And for that reason, I'm asking that the new structure be allowed to be placed on the property line without a 20-foot setback and basically in the same location where it exists now. And the new structure does not show up on my plat, but basically it is, if you can go to, well, it does too. I've marked generally one yellow where the proposed new structure is. I'm happy to answer any questions that any of y'all may have.
Okay.
I don't know what else I can say other than what I've just said. I could talk for longer, but I don't want to take your time or bore you with something that I think is unnecessary.
I'm going to ask you some questions, and then we'll allow each of the board members to ask their questions. Looking at the plat that we see in front of us here with the photographs, is the location of where you want to put the structure highlighted in yellow there?
Yes, sir, that is correct.
Okay, all right. You stated that, well, this may be a question for the staff, that the current structure had been there was placed there prior to incorporation by the town. So does this qualify as a non-conforming use? Although I guess if it does, you want to replace it, it has to meet code.
And sir, I'm a little vague. I've represented this enterprise since construction, which goes back to 1968. I am not dead certain, I'm sorry, 1971, 72. I am not dead certain, as we sit here today, the exact date that the structure that is there now was put in place, but I know it was quite some time ago.
Okay. In the second paragraph of your statement of facts, you have the lead sentence that says, The appellant's position is in the area in question that was reflected on a plat prepared October 29, 2009 as the lane, copy of which is attached as Exhibit 1. Was that plat approved in some way officially by the town of Hilton Head Island?
The only bit that I know of it was approved, and basically the plat before you is the same plat that's referenced in that statement. It's just a enlarged version of that. And then what happened was when the drainage was cut, the drainage ditch was cut, the town approved that and also approved changing the name from lane to a permanent stone drainage easement.
Okay. Could you explain to us, Mr. Bowen, how this is used, this lane is used for pedestrian access to the beach?
I don't think it is. Well, it certainly would be available for that. For lots 16, 15, 6, and C16, C15, C6, and C5. But to get to it, they would have to go across either the lots alone individually, because those 2, 4, 6, 8 lots are owned by individuals, or conceivably, and I am not sure, frankly, who owns title to the quote lane, end quote. I do not know who owns that.
So your I don't want to put words in your mouth, but your statement to the board is that this lane is not used for pedestrian access to the beach?
To the best of my knowledge, it is not. It's overgrown.
Okay.
There's no pathway to
All right. That answers my question. Let's go on then. Let's see if board members have questions for Mr. Bowen. We'll start with Mr. Johnson.
I have no questions at this time.
Okay. Mr. Walczak?
Nor do I. No questions at this time.
Ms. Bryson?
Yes, sir. I do have a question. I've tried to enlarge the plat as best I can on my screen, but I understood the presentation by Mr. Bowen, for Mr. Bowen to say that the lane, unopened lane, a drainage easement, whatever it is properly called, does not extend to Folly Field. But I do not see an ending point before Folly Field. Perhaps you could point that out to me. In the one I'm looking at, I see the lift station location along Folly Field. And I will disclose for the record, I have been out there to look at the site. I think we're expected to do that. So I'm familiar with the location of the lift station. And then on the plat I'm looking at along Folly Field Road is shown lot D as in David, 12. So I don't see, I just see the word Folly Field Road. I don't know where the right of way is, but I understand you to say that this unopened lane or drainage easement does not extend to Folly Field Road. Can you tell me where that evidence is?
Before he does that, Mr. Bowen, hold just a second. Ms. Bryson, you are referring to what's called Exhibit 2, which I guess is up now.
Yes.
Okay. All right. So we're all looking at the same thing. Okay.
Yes.
Mr. Bowen, please proceed to answer Ms. Bryson's question.
Let me call your attention to picture number 2. And that is also identified further on the plat on the right-hand side of the lane, which shows that a drainage ditch that is 20 feet wide and 10 feet, doesn't show the depth, but it is 10 feet, approximately 10 feet deep, transgresses the lane. So there's no way that vehicular access could enter Folly Field Road from the lane, street, unless there was a bridge across it. because it cuts it off. As you'll see where there's on the plat, it's called picture number 2, a storm structure. And the storm structure extends across the, my directions, I believe, are sort of northeast of C16 and C17. It cuts across the entire length of the drainage ditch, so you could not have any kind of access. You could have access by a mountain goat, I guess, but it would be too deep to walk, too wide to jump, and too deep to walk through. If pedestrian access was sought, and certainly no vehicular or bicycle or any sort of motor transportation access to Folly Field. So what you have is, on the other side of the ditch, you have just a stub of land that doesn't provide ingress or egress to anybody.
Yeah, yes, sir, I understand that physical impediment, but my question is about the platted survey, which shows that the end of that unopened lane appears to come near the edge of the pavement for Folly Field Road. So I may have misunderstood what you said, but I understood you to say that unopened lane, as shown on this plat, does not go to the right-of-way of Folly Field. So perhaps I did not understand your statement about that. What I'm looking at appears as though it does extend to perhaps the right-of-way for Folly Field, but the right-of-way is not indicated, only the edge of pavement.
Well, I don't know what else to say other than to call your attention to picture number 2, and also to the plat itself, which shows a drainage ditch transgressing the lane.
Yes, sir, I see that.
I don't know how else to answer your question, man, because clearly you cannot access the 400 or so feet beneath that goes on in the other direction up to Folly Field Road without some sort of a structure across the drainage ditch, and none such exists.
Yes, sir, I understand the physical impediment. Thank you. No further questions, Mr. Chair, at this time.
Okay, Ms. Loudermilk?
No questions.
All right, okay, Mr. Walzak?
Yeah, Mr. Bowen, you mentioned that you've been involved in this property since day one. Can you tell us what the reason was for this 20-foot lane back when it was, devised?
I have no idea. I represented the Island Club since its inception of construction, but I have no knowledge what's on the ownership or dedication of the property to the east of the Island Club, to where the lots are. I don't know. I have no information as to. I did get a call this weekend from a lady whose name I did not recognize, who questioned me about the stakes that are on the ground and are shown in pictures 1 and 2, and wanting just 1 and 2, and wanting to know that if that in any way challenged the ownership of the properties, because she was on the board of a community association. I've forgotten which one it was, and I assured her that there was no attempt at that at all. That was simply to demonstrate certain things that we were trying to bring to the attention of the appeals board with respect to what we believe the misnomer of a lane, or a conversion of a quote lane to a street as defined by the LMO.
So are you saying that you don't know who owns this lane?
I do not. I know it's not the Island Club.
And it's not the town?
Sir, I'm sorry, I can't answer that question. I just don't know.
Okay. All right, thank you.
I think my guess is it is open space for Folly Field Subdivision. That would be my intelligent guess.
Mr. Bowen, I have a couple of questions for you now.
Surely.
Looking at what's up in front of us, Up where it says water company, that's right above that is Folly Field Road.
right?
And we have lots D11 and D12. And below that, the 20-foot canal right of way. So that's the 10-foot deep, 20-foot wide ditch you're talking about. And from time to time, does water flow through that?
I suppose it does, but I can't state that as a fact, so I don't know.
Okay. And then in almost vertical presentation on the right side where it says Island Club Tennis Club, just to the left of that, it has the language of a 20-foot unopened lane. And if I turn my head sideways, I can read it says permanent storm drainage easement.
Mm-hmm.
So could you explain to the board what that 20-foot lane or easement looks like? You've shown us a couple of pictures here, but does water flow it from time to time if it's a drainage easement?
I'm assuming it does, but sir, I don't know that for a fact. The only thing that I can call your attention to is photograph number 2, which is outlined in red, the area of the ditch. As you can see, the area of the ditch is heavily overgrown. And to the best of my knowledge, it continues that way on down towards the beach. But I cannot state unequivocally that water flows through it because I honestly don't know.
Okay, that's fair enough. Thank you. Anyone else for questions for Mr. Bowen? Hearing none, that will conclude the appellant's presentation. I believe that Curtis Coltrane is on today, who is the city attorney. Mr. Coltrane, are you on?
Yes, I am.
Okay. I have one question for you. The plat here, and I don't know how official it is, talks about a 20-foot unopened lane, and below it, it says permanent storm drainage easement. So my question is, can a parcel of land be both an easement for drainage and a street or lane, or does it have to be one or the other?
It can be both. For example, in Hilton Head Beach Subdivision number 2, the town does not own the streets, but the town does own an easement that allows for the town to install and maintain underground drainage infrastructure there. So it serves as both the street and the drainage easement for the town in the same area. I, like Mr. Bowen, though, have no knowledge of precisely what the documentation that establishes this easement says or anything like that. I mean, I've only got what is in front of you, which are the 2 or 3, the 2 plats and then the one excerpt from one of the plats. But the short answer to your question is that both could exist in the same space, yes.
Okay, and then one other question. If it's a lane, it's represented as providing beach access from Folly Field Road to the beach. But Mr. Bowen's testimony has established that there's a 20-foot canal that bifurcates or cuts through this. So from a legal standpoint, how could we treat this as access to the beach when it appears there's a sort of a break in that area that would prevent access to the beach?
Well, I don't know that that's so much a legal question. What Mr. Bowen has described is the existing physical condition in the property, and the existing physical condition could be altered either by a bridge or by putting the drainage line that runs through there in a pipe and covering it up. I mean, you know, the fact that today there's an open ditch there doesn't, in my view anyway, and obviously I'm just, you know, I'm not on the board, so but in my view the current physical condition doesn't change what is shown on the plat. I mean, someone may have to make some alterations to that area to make it more user-friendly, but the current condition to me doesn't undo what it actually is.
Okay, all right. Thank you very much. We've heard from the appellant, and board has had an opportunity to ask questions. Now we'll hear the staff presentation. I believe Nicole Dixon is going to present this case.
Correct. Thank you, Mr. Chairman. Nicole Dixon for the record. Curtis answered some of the questions that I was going to address, just about the fact that it's currently unimproved, but it could in the future be improved to serve as access. So this process started back in December of last year, where the applicant submitted an application for a storage shed to be constructed on the property of the Island Club. There is currently a storage container that is serving storage purposes. The town does not have any record of that being permitted. It is currently non-conforming because it's located in their setback and buffer. We could not find, looking back at aerials, we could not find that it was there a long time ago, where it would be considered a legally non-conforming site feature. It was not permitted and would not be permitted. So the proposed shed would have to meet all LMO requirements as they are today. And going back and forth with the applicant, and you saw in my determination letter that that's part of the record, the applicant had the choice of, applying for a variance to have the shed constructed within the setback or buffer, or appeal my determination, and the appellant chose to appeal my determination, which is basically that platted out right-of-way, which is labeled as a 20-foot lane, is considered a street by the LMO, by the standards of the LMO. And if you look at the definition of a street in the LMO, it says a platted out street right-of-way, either existing or planned. So the fact that it's currently unimproved does not mean that it's not still considered a street. It's platted out, it's parceled out. I did receive a phone call this week from the Folly Field Homeowners Association representative on the board, who said that they owned that piece of land, and it was in fact a right-of-way for drainage easement and potentially future pedestrian access, and that they did not want at this time to improve it, but did not want any changes to it at this time. So they just were inquiring about what the appellant was appealing, and I explained the situation, but they did say that they owned that piece of land. Go ahead. Did you have a question?
I need to ask the question whether that statement from Folly Field is permissible if we don't allow public comment on an appeal.
I guess I'm not really providing it as a public comment, more of she just wanted to clarify that it was them who owned it and not the Island Club, and was questioning why there were survey ties on the property when they didn't grant permission to have that piece surveyed. And that's when I directed her to contact Mr. Bowen, as the town was not the one who surveyed it, but the appellant did. So it was more of a clarification conversation that her and I had, not public comment.
Okay, thank you.
You're welcome.
Please proceed.
Okay. So by definition of street in the LMO, that 20-foot parceled out lane is classified as a street. It does require a setback and buffer from it. And it would either be, if it wasn't a street and it was an adjacent property, then it would be an adjacent use setback and buffer. So either way, there's a setback and buffer required between the uses. Staff finds that it's an adjacent street setback and buffer because of the fact that it's a lane. And staff believes the more appropriate route would be to apply for a variance should the appellant feel they have no other available property for this storage facility. But that's all I have, unless you have any questions for me.
I do have one. Looking at what's on the screen right now, where the proposed location of this storage building is marked in yellow, it appears to be in looking northward in the northwest corner of an existing parking lot. In the lower left-hand corner of the parking lot, it appears to be further away from this 20-foot unopened lane. Nicole, do you have any sense of whether the lower left-hand corner of that parking lot is outside the 20-foot setback requirement?
I mean, I think it's hard to say by looking at this plat. So if that's a 20-foot wide lane and you take that dimension and kind of duplicate it next to it, I believe that they do have area next to that building number 9, where they could potentially put that storage shed. It would have to be behind the parking, but that would be up to the applicant to decide or determine, if they have any other available area. I'm going to pull up an aerial just so you can kind of see what this shows up. So I highlighted in red the area where they're proposing the shed, but I think from what you're saying, if they were to...
Well, whatever it is you're showing hasn't come up yet.
Okay. Let me see.
Nicole, this is Teresa. Which photo would you like to share? I may have a better connection. I can try.
Okay, aerial 2.
Sure.
Did it come up for y'all?
No, it did not.
See if I could try it again.
Nicole, I think we're both trying to share at the same time.
I haven't touched it again.
Oh, okay.
Well, let's move on. I think what we may have established is there might be an opportunity for a different location. Or is this it?
Yes, that's it. So you can see the aerial photo now?
Yes.
Okay. So in red is where the proposed shed location is. So I believe that there's potentially some other areas on the property where they could put a storage shed where it would be behind the 20-foot setback and buffer. Again, that would be up to the applicant to explore that alternative. But the LMO does require a setback and buffer, and we cannot permit a shed within that without the applicant going for a variance.
Okay, thank you. I interrupted your presentation. You can, with a question, you can proceed.
I didn't have anything else. To staff, it's pretty cut and dry. The lane is parceled out as a right-of-way and requires the setback and buffer. And that completes my presentation if you have any questions.
So just to go back to something you said earlier, I believe you're testimony was that staff could not document that this had been granted or was grandfathered in as a non-conforming use?
That's correct. It would not have been permitted in the location that it's in, and the town does not allow shipping containers or storage containers for storage unless it's tied to a building permit. So it's not something that the town would have granted approval for, and the town does not have any records of a permit being issued for it. So
Okay.
it's not.
Okay, thank you. Let's see if board members have questions. We'll go in reverse order from last time, and that means Ms. Loudermilk, you are up. If you have any questions.
Yes, Nicole, and I happen to be, I'm looking at my copy of Exhibit 2, but I think your aerial also may have showed this well. The unopened lane, as it's referred to on the exhibits, the 20-foot unopened lane, it does appear that it stops at a parcel owned by Folly Field property owners prior to reaching or approaching the beach. So if I'm looking at that correctly, this lane in and of itself would not be able to provide access to the beach. Am I looking at that correctly?
Well, it provides access to that to their other owned parcel that would lead to the beach. So
yes.
the intent, I believe, when it was originally platted years and years ago, was that that would be at some point an access to the beach.
But this particular lane parcel stops at that other property, which is owned by Folly Field property owners.
Correct.
Okay. All right. That's the only question.
Okay. Thank you, Lisa. Patsy Bryson, questions for Nicole?
Yes, sir. I was going to ask a similar question based on the aerial, which I appreciate, but it's disappeared. So moving on to the next question.
Would you like the aerial call back up?
I think it would be helpful because I think it would help us to see what Ms. Loudermilk was asking about. Thank you, town staff, for doing that. So yeah, it does appear as though that lane, it's now shown on this plat as the 20-foot unopened lane. It does appear that ends, it's impossible for us to tell whether or not that's the end of Folly Field subdivision. It appears as though from the plat, there's another property owner called Folly Field Property Owners. So we don't know whether that's part of the subdivision or not, but notwithstanding that, on both the aerial and on the plat presented, it shows that the lane ends and does not go all the way. The question that I have is about the definitions. Ms. Dixon, pardon me, you referred to a definition of other street or street other. I can't remember which way it goes. I have to go back to my other screen to look. But I'm looking in the LMO and I cannot find a definition for other street or street comma other. Can you direct my attention to the subsection where that definition appears in the LMO? Because I'm looking in chapter 16, I guess it's article 10 where the definitions appear. Then I also looked back at 16-5-102 for setback standards. And I haven't had a lot of time to look for it, but I'm not finding it. Can you direct me to that definition?
Sure. So street is defined in the LMO in Chapter 10 as an existing or planned public right-of-way or private easement used or intended to be used primarily for carrying vehicular, bicycle, and pedestrian traffic and providing a principal means of access to abutting property. Then if you look in Chapter 5 under the setback standards and for setback and buffer standards as well, there's 3 different classifications of streets. There's major arterials, which is William Hilton Parkway, Palmetto Bay Road. Those types of examples would be considered a major arterial road. Then there's minor arterial roads, and these are all outlined in Chapter 5. There's a table that specifically lists what roads on Hilton Head are major and what ones are minor. And then if they're not in that table, they're classified as an other street. So when you're looking at the setback and buffer table, there's those 3 options. So a street is either a major arterial, a minor arterial, or an other street. And so if it's not listed in that chart, or in the table that specifically lists major or minor arterials, then it's classified as an other street, which this lane would be considered.
Okay, forgive me. I am looking in 16-5-102, and I'm looking at setback standards C, adjacent street setback requirements. Is that where you're directing me? Because I have not yet found other streets in there. A definition of other street.
Let me see if it's actually, hold on, I'm going to pull up the LMO real quick.
Sure. Because I'm not sure that if a description there is a definition to use, it's not, when there are specific definitions for streets.
Well, it's not, it's in Chapter 5, I'm not considering an other street a definition. It's more of a use classification. So it's how the different streets on Hilton Head are classified.
Okay,
And
so then we should only look at the definition section. Is that correct?
Well, if you're looking for the definition of street, then yes, you would look in the definition section, which is in Chapter 10. And I read you that definition.
Yes, ma'am. And so there is not a definition for other street. There's only a definition for street, private, and street, public. Is that correct?
I believe so. I'm looking that up real quick. Give me a second.
Okay. Sure. Take your time.
Right. There's a definition of street, then there's a definition of street, private, or street, public, but not other. And like I said, those are just the way that the different roads are classified. If you go back to under Chapter 5 and you go to Section 105.
Okay.
And you go down to the street hierarchy. That's where you'll see the different designations for the types of streets. So that's where 16.5.105B lists what the major arterials are, and then the minor arterials, and then streets that are not listed there would be considered other streets.
Yeah, I'm still not seeing other streets in there. I'm exactly where you sent me. Street hierarchy.
Right, so that's where the major and minor arterials are listed.
Yes, I see that.
And then just by way of interpretation, I guess, any other street on the island would be considered or classified as an other street because it's not a major or minor arterial.
Okay, so there is not a definition of other street. Is that correct?
That's correct.
Okay. All right. Then if I could ask you to go back to the definition of street in 16-10-105. And in my copy of it says, and I'll just go to the second sentence, used primarily for carrying vehicular, bicycle, and pedestrian traffic, and providing a principal means of access to abutting property, not the same property as in the same subdivision, but abutting property. So it appears as though a street has to be used primarily for carrying vehicular, bicycle, and pedestrian, not or.
Mm-hmm.
So my question is, if this is a 20-foot other street, then how could it possibly carry vehicular traffic? Because as I understand, there's some requirements for street standards within the LMO. And so would a 20-foot right-of-way suffice for a street under the LMO standards?
Well, it's currently an unimproved street, so it could be improved at a later date and incorporate pedestrian access or drainage or any of those other standards within the right of way. Now, we wouldn't allow a street to be established, so we wouldn't permit currently a subdivision, say, with just a 20-foot wide right of way through it, because that doesn't meet the current street standards. But at the time when this was platted, it was platted as a 20-foot lane. So, you know, if Folly Field homeowners at some point want to improve that as an access, then at that time they would have to meet certain design standards. And I'm not sure exactly what would be required. I don't know if additional right of way would have to be acquired or anything like that, but it is platted out as a planned lane.
Yeah, and my question remains, if buffer and setback standards are to apply at this location, then you're saying that it's because it's an other street. And there's no definition for other street, so we have to go back to the definition for street itself, which requires that it be used or intended to be used for carrying all three, vehicular, bicycle, and pedestrian traffic. And so that's why I can't understand why it is being called a street, because it's my understanding that what you're saying is if it's an or, so if you could use it for pedestrian or bicycle traffic, then it is a street. But it also is my understanding, in just reading that language there, unless there's an interpretation which is contrary to my understanding of choice between and or, that it must be able to be used or intended to be used primarily for carrying vehicular, bicycle, and pedestrian traffic. And so that's why I'm puzzled about it being determined to be a street.
I mean, all I could say is it was platted out as a right-of-way. It was platted out as a lane. Whether it can meet today's current street standards to be improved, that would be to be determined. But it's either a street or it's an adjacent parcel. Either way, there's a setback and buffer required from it. The town believes it's classified as a street per definition.
So if it were a 10-foot easement, would you then also classify it as a street?
I mean, it would depend on how it's platted out and how, you know, the legal plat names it as a lane. It's platted out, parceled out. It's not parceled out as an easement. It's parceled out as a lane.
Okay, I don't have any other questions, Mr. Chair.
All right. Mr. Walzak, any questions for staff?
Yes, a couple quick ones. The lift station up near Folly Field Road, that seems to be within a buffer. Did they get an easement or rather a variance for that? Hello?
I do not know, and I'm not sure how long that's been there. But
Okay.
I do not know.
All right. The next thing is this lane has been there again since 1981 or whatever, before the town was a town. So obviously all this stuff was filed with Beaufort County. Aren't there records that indicate what this lane or drainage easement was meant to be, in the covenants that were filed or whatever, that would better define this thing?
I mean, I could not find anything other than the plat that was included in your packet that shows it as an unopened lane.
Okay.
And the drainage easement that was recorded.
And the third thing I have really is for Mr. Bowen. Isn't there another place on this property you can put that dumper? Can't hear you.
Mr. Bowen, you must be muted. We can't hear you talking.
Unmute. You got muted.
Go ahead.
Okay.
Go ahead.
Thank you. I can see that. First of all, two things that I wanted to comment on. Where the yellow is, the area below the mark in yellow on the plat, a building already exists in that area. It's not ours. Another building exists in that area. Secondly, I would like to tag on to what I believe it was Ms. Bryson said when she was reading the conditions for a street. There was an additional one, and that was, and providing principal means of access to abutting property. Well, there's a chain link fence along the abutting property. There's no way that you could abut it through, that you could access it through there. We looked all over to see if we could find another location, and because of restrictions of either lagoons or other things, there was no other place that we could find a lagoon, that we could find a place to put this structure. Again, I believe it was in place before the town was created. I can tell you when the town was created because I was chair of the county council, and that was back in 1980, I believe. But I think this was already there. Note, I said I think. I'm not testifying as to the truth of that, but I believe it was. But again, you just can't reach out and create a definition for something that does not support the requirements of that, a street. I can find nowhere where a lane was, the term lane was ever incorporated in any definition of a street. I've given you the definitions of street that I could find. And I think by the LMO's own language, it doesn't constitute a street. But in any event, I appreciate y'all's consideration of the matter, and I appreciate the time that's been spent by Ms. Dixon in setting this up. And I thank all of you for your attention to the matter. I just maintain that this ain't a street.
Thank you, Mr. Bowen. Mr. Walsack, other questions?
Yeah, it seems to me that more research has to be done to find out. I mean, he has a point. Maybe that was there before the town was a town. That's why they have no record of it having a building permit.
Okay.
So maybe it seems to me more research should be done before anything.
Okay, we're at the question stage, not the discussion stage yet.
Okay, well, then I withdraw my comments.
Mr. Johnson, any questions for staff? Bob Johnson?
Yes. Nicole.
Yes, sir.
I'd like to say that this piece of property, because of its connection with Folly Field, probably goes back to the 50s when Folly Field was started. Is there any evidence of that?
Again, I could not find anything but these plats. I don't know how far it went back or why it was only created to be 20 feet wide. I can just go on with the plat that was recorded and what it shows it as.
Okay, I wanted to ask a question. This follows up with Patsy Bryson's question about could this lane or easement accommodate a one-way street with setbacks on either side of it?
Well, setbacks.
LMO.
Setbacks from a street are located on the adjacent property, so the setback and buffers aren't contained within the right-of-way.
So it would accommodate a two-lane road or street or one lane or neither?
Right now, I'm not sure if it would meet all street requirements because there's other components of a street that would have to come into play, whether there's adequate, and I don't even know the proper terminology, but adequate shoulders and all that. So I don't know exactly. I can pull up.
Does the LMO address one-lane streets?
It does. I'm pulling up that section real quick. Hold on. So if you look at 16.5.105 D1 for street standards, for a new lane today, to meet LMO standards, would have to be a minimum of a 30-foot right-of-way with a 20-foot pavement width. So because that was platted at just 20 feet, it could be improved with just 20 feet pavement width, but a new lane would have to be 30 feet wide.
Okay, thank you.
You're welcome.
Could we call up the Exhibit 2, please? Which is the plat, I guess.
The one with the pictures on it, or just the original plat with the drainage easement?
Oh, the one with the pictures, I guess, works.
Okay.
I need to see it before I can say definitively.
Can you see the plat?
Yeah, but that's not the one I need. Could we go to the one that goes all the way down to Folly Field property owners?
This one?
No. There was one, it was Exhibit 2, Attachment A, Exhibit 2 to Mr. Bowen's presentation. It's the one that runs from Folly Field all the way to the Atlantic Ocean. I think. Yes.
Mr. Chair, I think it's Exhibit 2, Roman numeral 2, not 2A, but 2.
Well, it's.
This one?
Yes.
Yes.
Testimony was just made that it could be developed into a road with 20-foot pavement, but it would be a road to nowhere because it ends at on the south end by the ocean, or east end, I guess, with Folly Field Partners. Mr. Bowen, you had testified earlier. You made a statement about a chain link fence, and I was confused as to where that was. Is that on the Island Club property side, or is it on the various lots of Folly Field subdivision? Mr. Bowen, can you hear me? You need to unmute your microphone.
I can't do that at this end. Y'all have to do that.
Okay, all right, they just did it. Go ahead.
There we go. That's on the Island Club side.
So running all along the Island Club property line is a chain link fence. Is that what you're telling us?
It may stop where it reaches the drainage ditch.
Okay, but for most of the Island Club property on its side of this unopened lane, there is a chain link fence.
That is correct, sir.
Okay, thank you. That's all. That's all I needed. Thank you for your answer. Let me go back to the definition of street. And at the end of that definition, as Ms. Bryson pointed out, it requires carrying vehicular, bicycle, and pedestrian traffic, which this is not capable of doing, and providing a principal means of access to abutting property. And looking at this plat, this appears to be a lane to nowhere. The canal bifurcates it a little east of Folly Field Road, and then it dead ends at lot C4 and 5, I guess. So I'm hard pressed to understand how this really qualifies as a street. But question from Ms. Dixon, if for a moment we can concede that it is, or consider that it is not a street, then what is it? And you had told us about a setback that would apply even if it's not a street. Could you
That is
enlighten?
correct. So if it's not considered a street, then it's considered an adjacent property. So then the setback and buffer table that is applicable to adjacent use would apply.
But the easement, we have heard testimony that nobody knows who owns it. And so would not the adjacent property in Folly Field subdivision end at the property line of lot C 16, 15, 6 and 8, I guess it is, hard to read. And wouldn't this unoccupied lane or unopened lane actually serve as the 20-foot buffer?
So there's an adjacent use buffer between two adjoining uses. So there would be an adjacent use setback and buffer from the Island Club to the Folly Field Homeowners Association property. And then when that original subdivision was approved, then, and I get that it was approved before the town incorporated, but there, per town standards, there should have been a setback and buffer around the perimeter of that subdivision. So if the board decided that that lane was not a street, then it's a strip of land owned by the Folly Field HOA and would be considered, it would require a setback and buffer from that. So it would be whatever the use of the Island Club is, which is multifamily to single family, and that's how you would determine the required setback and buffer.
But I thought we heard testimony earlier that the lane is not owned by either Island Club or Folly Field.
I'm not sure who told you that. What I mentioned was I received a phone call from a representative of the Folly Field HOA, and they said that they did own that street or that strip of land.
So the facts that we're hearing now are that the Folly Field subdivision goes up to, looking at this, the right-hand side of that unoccupied lane. Is that what we're saying?
It's my understanding that the Folly Field HOA owns that unopened lane.
Okay, thank you. That clarifies that.
Mr. Chairman,
Yes,
are we under discussion or where are we? Because I have a question. Do I wait till discussion?
if you have a question, we can take it now.
I have a question for Nicole and an observation.
Go ahead.
There's nothing that says this street lane has to connect all the way from Folly Field to the ocean. I don't know why, although it's not the principal means of access to these lots, but theoretically they could connect those two streets together. For what reason, I have no idea, but we're looking at it like they have to go from Folly Field all the way down to the ocean. Maybe that's not the proper way to look at it.
Okay.
What was the question? I'm sorry.
The question is, could they just not, could they connect the two streets that dead end from Folly Field with a street?
Technically, yes. They own that piece of land that is platted out as a lane. So if they wanted to improve that as a street, they could.
I keep going back to it wouldn't have to be the 2-lane street. It could be a one-way.
Okay.
And that wouldn't require as much land, I would think.
All right. Does anyone else have any questions for staff?
Yes.
Patsy, you raised your hand. Ms. Bryson?
Yes, sir. Ms. Dixon, I'm not able to read this on my screen. I apologize. Perhaps you won't be either, but on that same exhibit we were looking at, the plat, which is exhibit Roman numeral 2, where the language is 20 unopened lane, then there's language permanent storm drainage easement, and then there is a reference to a plat book and page number, which appears to be plat book 141 and I think page 114. Is that the plat we're looking at, or is that another plat?
That's the drainage plat. I'll pull that up on the screen.
Okay.
So this, do you see the plat up on the screen?
Yes, ma'am.
Okay, if you look at the bottom right-hand corner, there's a county recording information, and it shows the plat book and page, so that's what that's referring to. It's this drainage easement.
The drainage easement that crosses over the 20-foot unopened lane?
The drainage easement that goes from Folly Field all the way down to the Folly Field POA property.
Okay, so the plat you have up now is different from the one we were looking at. Is that the one that is plat book 141 at page 114?
Yes, this is that one.
Okay, thank you. Let me just take a quick look at that. Okay, so that actually labels this lane then as a permanent storm drainage easement.
It's an easement. It's an easement that's encumbered in that lane. So they both function, or they both are within each other. There doesn't have to be an either or. Like Curtis mentioned earlier, you can have an easement that runs through a lane.
I understand that. Yes, ma'am. Okay, I just wanted to find out if we had that plat book and page as part of the documents before us. So, okay. So a question that was related to what Mr. Cottrell was asking about, and that is, if the board determines that this is not a street, then it's my understanding that the staff would make a determination that the setback and buffer requirements still apply, because the staff would be determining that this 20-foot lane, also known as a 20-foot storm drainage easement, is an abutting parcel.
Correct.
And so we'd be back to where we are right now.
That's correct. Either way, there's a 20-foot setback and buffer required from the Island Club parcel to the Folly Field owned parcel.
Okay. And if we then look at the definitions to determine whether or not this 20-foot lane, 20-foot permanent storm drainage easement is a parcel, then under the definition section, when you look at parcel, it refers to the definition for a lot. And so that's what I'm looking at right now. And if you want to pull that up to be able to address my question.
Sure.
And I first looked at parcel, and then that led me to lot. And if I'm missing, you're way more familiar with these definitions than I am. So if there's something else I should be looking at, I hope you'll direct me. But under the definition in 16-10-105 for parcel, it says C lot. And then when I look at the definition for lot, also within 16-10-105, I see the definition, a legally described piece of contiguous land that has been or may be developed as a unit. This term is synonymous with parcel. So my question for you, if that's the proper definition to apply, is the first question. And the second question is, if it is, how could this be developed as a unit?
Well, I don't think that that piece of land is considered a lot because it's specifically recorded as a lane.
Okay. And so, and forgive me if I've gotten the wrong terms that you use, but I understood you to say it's an abutting parcel. And so that's why the buffer and setback standards would apply. But when I looked at the definition for parcel, it sent me back to the definition for lot. And so that's why I'm puzzling as to why this is considered an abutting parcel when you must apply the definition for lot.
So staff feels that it is a lane, that it is a right of way. And what I had said was, if the board decides that it's not a right of way, it has to be something. So if it's not a right of way, then it's a piece of property. And that's where an adjacent use setback and buffer will be required because you're going from one use to another. But staff has not changed its determination. We find that it is a street.
Okay, so you are not changing your interpretation today. You are saying it is a street, and if we find, I don't know how we're going to decide, if we find that determination is inaccurate, then does that mean you will not change your interpretation to call it an abutting parcel?
You confused me there.
I'm sorry, I did not mean to. Let me try again. So you're saying today you're not changing your definition, or sorry, determination that this is a street. And so my question then is, if the board, and I don't know what the board will decide, if the board decides this is not a street, that was an error, then are you telling me that you're going to stick with that determination, or will you then say, okay, now it's an abutting parcel? And so my concern is then we're going to be coming back perhaps with another appeal over whether or not it's an abutting parcel. And I'm trying to address that before that happens.
Well, the appeal before you today is they're appealing my determination, and so the board can uphold my determination, or vote or make a motion that I've erred on my determination. And so if the board finds that it is not a street, then staff has to go on what the board finds. So I can't say, well, I'm going on my determination. So we would have to go on what the board finds, and it would be an adjacent use at that point instead of an adjacent street.
Okay, so, and I apologize. So now we need to be confronted with whether or not it's an adjacent use and look at that definition. Mr. Coltrane, Mr. Chair, if I may ask Mr. Coltrane a question.
Go right ahead. I think the term that Nicole used, though, was adjacent property. I'm not sure that property or parcel is critical to the discussion. I wrote down adjacent parcel. But go ahead with your question, Mr. Coltrane.
Yes, sir. Thank you, sir. Mr. Coltrane,
Yes.
don't know what the board will decide, but if the board decides that the staff erred in determining this to be a street, may the board then decide what this is to be called?
I don't believe that is the question that is before the board today. The question that is before the board today is whether or not the decision made by Nicole in response to the request of the Island Club regime is correct or not.
So is there a procedural way to prevent my semantics is coming back with a different term?
I'm not sure I understand how you would do that, because once, assuming that you decide that the decision of Ms. Dixon was incorrect on what the piece of property is, then, you know, a number of things could happen following that based on actions that the applicant may take or not take. And there's going to be perhaps a new determination made. I mean, but that question of a determination that may or may not ever get asked for is really not before you today.
And if we determine that it is not a street and instead it is a, you know, whatever term we want to use, because we have to include some sort of finding and the reason that if we determine that the staff made an error in the determination, that that's part of our finding, I guess.
Well, your finding would be in the event that, you know, again, not trying to prejudge what y'all might do, but if your finding is that for, reasons 1 through 5, or ever how many you choose to quote, you find that Ms. Dixon incorrectly determined this to be a street, then you reverse her determination. But I mean, right now, that's the question that is before the board.
Okay, thank you, sir.
Any other questions, Ms. Bryson?
No, sir, thank you.
Okay, Mr. Walsack?
Yes, for Nicole. Nicole, you mentioned the dimensional requirements for a road, that comes out of the LMO. Could a road be built in here that does not meet the requirements of the LMO? In other words, a private road?
I mean, I don't know that I can answer that right now. I mean, we'd have to look at what was being proposed and, if it was one way versus two way, if it met all of the LMO standards, if it met engineering standards.
Yeah, but it would be a private road. In other words, it's not open to the public. So would it have to meet it'd be like a driveway. Would they have to meet roadway requirements, or could it just be a driveway?
Well, it's a right of way, so it couldn't just be a driveway, but they could do like Mr. Johnson said and do a one way. It would have to be signed appropriately and that sort of thing. But
maybe it doesn't even have to be paved. Yet I'm sure there are town regulations about paving roads.
it would have to be constructed with an all-weather driving surface. So it could be 20 feet wide as an access easement and meet fire rescue standards, which would be 20 feet wide and an all-weather driving surface. It would have to go through our development plan review standards, or development plan review application, and meet all those application standards. So it would be reviewed by engineering and traffic engineering and all those different divisions.
Okay, so in other words, there's no such thing as a private road in the town.
Private in the sense of who owns it?
Right, private.
And there are private streets on the town, but they still have to meet LMO standards.
They do. Well, then there's no difference in the geometrics of a private road versus a public road.
That's just ownership. There's no standards that differentiate between the two.
Okay, thank you.
Okay, Nicole, I'm sorry, were you done, Charlie? Okay. The basis for the appeal, Nicole, from Mr. Bowen, first of all, let me back up. The determination, as I read in your March, I believe you wrote it, the March 24 letter. Yes. Your March 24 letter says, after review of the application, staff informed the applicant that the shed shown on the site plan needed to be moved as it was being proposed in the setback and buffer required from the street adjacent to the subject property. So the basis of your determination was that it was within a setback required from a street. The basis for Mr. Bowen's appeal of that determination is that it is not a street. If, and we are conjecturing here, if the Board of Zoning Appeals determined today that in fact it is not a street, then what happens to the plan to build a structure? The basis for the town's determination was that it was a street. If the board decides it's not a street, then where are we? That does not necessarily grant the Island Club permission to build a shed, does it?
No, because like I said, if it's not an adjacent street setback and buffer, then it's an adjacent use setback and buffer. There's
So,
still a 20-foot requirement that they have to be
so
behind.
then, if I might go back into conjecture, if the board made a determination it was not a street, then the town would make a determination that it was the proposed building was being built within the necessary setback from an adjacent property. So from a practical standpoint, we'd end up right back where we are now. Is that a fair statement?
Should the appellant go that route? Yes.
Okay. Can we go to the, I guess it was the picture that was had the pink area for the proposed building? Did we look at that?
Sure. Try to pull that up.
No, that one doesn't do it for me. It's the one that showed where the building was going to be with the parking lot. And that's the one right there. Perfect. I guess we're still in questions for staff, but I'm going to propose a question to Mr. Bowen. In fact, let me just ask, does anyone else have any questions for staff? And then we'll get into general discussion. Hearing none, thank you, Nicole.
You're welcome.
We'll now move into the area of general discussion by the board. So I want to pose a question to Mr. Bowen. Mr. Bowen, the area in yellow is, as I understand it, where the Island Club wants to build its storage container or storage building.
That's correct. That's
okay.
correct.
It's in the upper left-hand corner of this parking lot. Why could it not be moved to the lower left-hand corner of the parking lot that looks like it would be further away from the lane?
There's already a structure there, sir. This does not show an existing structure, which is ocean side of the existing structure.
I'm sorry, say that again.
You see where the movable storage container is? And then if you drop down to the white space beneath that, there is already a structure there, sir.
Why could it not be moved further to the right about where the word property line ends and put it in the middle of that parking lot?
Well, we have an issue there, sir, with a parking spaces requirement.
But it appears to me that you're using some of the parking spaces now for this existing building. If you tore it down and moved it over to the middle of that parking lot, then you could recapture the parking spaces that are currently occupied. I guess I'm trying to find out, isn't there some other, to follow up on Mr. Johnson's question, isn't there really some other place this could be put?
Not that we could find, sir, and we went over it with, I believe, a representative of the town was with us when we were looking for alternate spots to create additional parking places so that we could do some of what you suggested, but we just couldn't find that.
Okay, and then one other question. In the staff's letter, it said that the applicant may also apply for a variance to reduce or eliminate setback and buffer requirements as outlined in the LMO. Why did the Island Club choose to pursue the avenue of an appeal versus coming to the BZA with a request for a variance to eliminate the buffer requirement?
Because it appeared to us that the decision to create a street where no street existed, by definition or otherwise, was just improper. And with respect to the additional setback for property, I think that's probably why that 20-foot setback is there, why that 20-foot buffer was there, was so there could be no buildings built closer to the chain link fence than 20 feet. And
Well, the testimony we've heard from staff is that the Folly Field Property Owners Association, I guess, or subdivision, ownership goes all the way to the fence. And if the board determines that that the lane is in fact not a street, it really doesn't give you the relief you're after, because staff is going to conclude that you then need the same setback on adjacent property.
With all due respect to Ms. Dixon, I don't believe that's correct. I do not believe that's correct. By way of information, the Folly Field plat was done in 1962. If you look at the bottom left-hand corner of the plat that's on screen now, someone, it seems to me one question was, do we have a plat that shows what the situation was and when it was? And it looks like it was done in 62. But I don't think, I just, we're here on one definition. If we had been told that even if we declare this is not a street, we declare that there's a further setback requirement, we'd be talking about that too. But here, the only reason that we're here today is because they classified it as a street, where I submit no support lies in case law, dictionaries, or common sense, where you could just change the name of something, say, well, that may be a lane, that may, but no, we don't call it a street. That's not within the authority of the council to do that, or the building department, rather.
Well, Mr. Bowen, the testimony that I'm hearing is that your appeal is that it shouldn't be a street, but if the board says it's not a street, it doesn't get your client where it needs to be, because you're simply going to bump up against a different kind of setback requirement.
I understand what you're saying, sir, but with all due respect, I don't accept her statement is being controlling, that another setback requirement comes into effect.
Okay.
I don't believe that's a valid position.
Okay, thank you. Go on with board discussion then. Bob Johnson, would you like to start us off and see if we can get to a conclusion of this?
Yes, I would. I don't know whether this is pertinent or not, and I'm not sure I can ask it, but how many acres is this project?
Are you asking me?
Yes.
Well, it's 20 by 400, and it's on the plat there somewhere. It's 20 by,
No, I'm talking about the whole Island Club.
oh golly. As I recall, you see, the Island Club is broken into 4 different ownerships, regimes 1, 2, 3, and 4. And each regime owns a certain amount. Regime 3, which is where this one's to be built on.
Is this building merely to serve regime 3? So it would have to be within their property.
That's correct, yes.
Okay. That's I wanted to clarify that. That's all the questions I have.
Okay, Mr. Walsack, any question? We're in questions. We're really in board discussions, hopefully leading to a motion and a determination by the board.
Well, the only comment I have at this time is based on the latest discussion I had with Nicole about the fact that a road can't be built there, according to the LMO, whether it's private or public. So if a road can't be built there, Why is it considered a road? That's all I have to say. I mean, it's, we got to decide somewhere, I guess.
Okay. Ms. Bryson?
Yes, sir. I think you could probably tell which way I was leading, but only ask after I got to ask some questions for clarification, because I really wasn't sure. I thought there must be a definition for other street because that was what was in the letter of determination. But based upon the definition of street within the LMO, this does not appear to meet that definition. And so that's where I'm leaning. My troublesome future is that I don't want us to be back here again. And if I understood Mr. Bowen to say that he was not told by the staff that if it's not a street, then it will be an adjacent use or whatever else it's called, and still would be back to the buffer and setback requirements. I do think that the LMO has requirements for buffer and setback standards, which should be applied absent there being determination that a variance is applicable with that specific application, certainly not this one before us. I'm troubled with the applicant having to come back again with a different determination. I wish that there were a way for us to avoid that kind of situation. I'm still thinking about how we could approach that, but at this point, I couldn't see calling this a street either. Thank you.
Thank you. Ms. Loudermilk?
No, I absolutely agree with what Patsy Bryson just said, and I feel strongly our role today is simply to rule whether or not staff's determination that the lane is technically a street, which is what has created the need for the setback buffer. We need to stay focused on that. We need to make that determination, and then staff and the appellant can, take the necessary steps based on what the next move is.
Okay. Did I get lost?
No.
We can still hear you, Mr. Chair.
Yeah, you're there.
Okay, well, I'm getting the screen that says my Blue Jean app is started. I guess long now, Teresa? Okay, I'm back. Stay. All right. Yes, I want to stay. Okay. Anyone else with any discussion? If not, would someone care to make a motion using the motion template? Charlie, you.
Mr. Chair, I'll give it a shot.
Go ahead.
Wait, Ms. Bryson, just a second. Mr. Walzak, you seem to.
Yeah, I mean, it looks like I have it right in front of me with all of the language. And it seems to me we could perhaps modify the determination based on the fact that it's not a street, but yet not grant the variance. So we just have to put that in, put that in some kind of language. And Patsy, you're the lawyer. Maybe you should put it in your language.
Well,
Recognize Ms. Bryson for a motion.
clearly I have to give my caveat. I'm a retired lawyer, licensed only in North Carolina, not authorized to practice law in the state.
Make it
Yes, sir. I have to give that disclaimer. Not authorized to issue any opinions. So with that said, I move to, and the language that I'm looking at is to modify or reverse the decision/interpretation. I'm sorry, I should stop, Mr. Chair. Ms. Haley, as you know, I'm probably using the appeal motion format. So
Yes, thank you.
yes, ma'am. Decision/interpretation because staff made an error in determining whether a requirement of the land management ordinance was met. for the following reasons. Number one, the 20-foot unopened lane, also shown as a permanent storm drainage easement, is not a street as defined in section 16-10-105 because it is not used or intended to be used primarily for carrying vehicular, bicycle, and, underlining the word and, pedestrian traffic, and providing a principal, underline the word principal, means of access to abutting property. Period. Number two, the use is more akin to an easement as defined in section 16-10-105 of the Land Management Ordinance. Period.
I'll second that motion.
We have a motion and second before the board. Is there any discussion?
I have a question on the motion.
Go ahead.
Don't we need to modify or reverse? So is the motion to reverse?
Yes, I will clarify that. I'm sorry, I was just reading right off the template.
Sure.
So it is to reverse. I apologize.
Yep.
Okay, thank you.
Agreed.
All right, so the motion before us is to reverse the decision of the town staff that the parcel in question is a street, and that is the full extent of the motion and the determination we're about to make. Any other discussion? Hearing none, Teresa, would you call the roll?
Mr. Johnson,
Not for the motion.
Mr. Walzak,
For the motion.
Mr. Katrier,
For the motion?
Ms. Bryson,
For the motion.
Ms. Loudermilk.
For the motion.
Motion carries 4-1, Mr. Chair.
Thank you. That concludes the discussion of this particular case. Mr. Bowen, you've heard the decision. You can deal with this as you see fit with your client. Moving on.
I was just going to say,
Yes, sir.
thank you very much for your consideration at this time.
Well,
Mr. Chair, I'm
Yes.
sorry. You might want to inform the applicant about our procedure, the notice of action, et cetera, and maybe you're getting ready to.
Well, what Ms. Bryson is referring to is there will be a notice of action written up, signed by the chair, the maker, and the seconder of the motion, and that will be sent out to the appellant as required by the town's procedure. So you'll get a formal statement about what we decided today. You heard the discussion. I think you've gotten relief from the question of whether it's a street, but I'm not sure you've gotten relief from the setback requirement, but that was not what was before the board today. Okay, moving right along, we have a recommendation for a meeting schedule for 2021. Hopefully each of you have had an opportunity to look at that.
Can I disconnect at this point, please?
Okay, thank you, Mr. Bowen.
Thank you very much.
We're back to the 2021 meeting schedule. Does anyone have any questions or comments on the proposed schedule? Hearing none, do we have a motion to adopt the 2021 meeting schedule? Ms. Loudermilk, you look like you're dying to make a motion.
I move that we adopt the 2021 meeting schedule as published.
Thank you. Do we have a second?
Yeah, I'll second it.
Okay.
Let Mr. Walzak second it.
I'll second it.
I'll second the motion.
Can I amend it, being subject to COVID-19?
Well, we're there.
I know.
All right. Any other discussion? Hearing none. Teresa, would you call the roll?
Mr. Johnson,
For the motion?
Mr. Walzak,
I'm in favor of that motion.
Mr. Cotrier,
For the motion.
Ms. Bryson,
For the motion?
Ms. Loudermilk.
For the motion.
Okay, thank you. The 2021 meeting schedule has been adopted. Now we move on to staff reports. I believe Nicole is going to give us an update on LMO amendments that had been recommended by the BZA in January and July.
I was just gonna mention that the list of waivers and the letter that was submitted by the board to the Planning Commission and Town Council is being reviewed by staff right now. And if staff finds that there are any changes that are necessary due to a certain number of waiver requests for specific items, or if the Planning Commission or Town Council requests that staff take forward amendments related to these waivers, it will be done as part of the 2020 LMO amendment set, which staff is currently working on. So at this point, I don't know that there will be any amendments related to that, but it is something that we are looking into, and if we do find that there is reason to have amendments, it will be on that list.
Okay, thank you. So it's in process. Any questions from board members for Nicole on that? Hearing none, waiver report, Missy Lewick.
Hello. In your staff report was, we've had one waiver since our last meeting, and it was for a project in conjunction with a development at 59 New Orleans, and it was related to some parking lot non-conforming features.
Okay, any questions for Missy regarding that? Hearing none. Our next meeting, as you recall, we have a special meeting set for 1 p.m. on Thursday, October 29, in which we will hear a series of, appeals or variances, I forget, on Sandcastle Court. Mr. Coltrane, I wanted to confirm my understanding that you will be with us at the Thursday meeting to provide.
Yes.
Okay, great. Thank you so much. Appreciate you making yourself available. Ms. Bryson, you sent me an email on the afternoon of the 22nd. I left town on the 22nd about 7 a.m., got back 2 hours ago, so I'll respond to it between now and Thursday. Does anyone have any other business come for the board at this time? Hearing none, we stand adjourned. Thank you for your participation.